Oldies 98.9, 1220, 105.3 WGNY. 1970 vintage right there, of course, from the album Deja Vu. Crosby, Stills, Nash, and Young, giving you the greatest music ever recorded on this Hump Day Wednesday and every day. Very special guest that I've been talking about all morning long, attorney Richard Shapiro. Richard, good morning to you.
Yes, good morning, Bob. How are you?
All right, I'm doing good. How are you doing?
Doing fine, thank you.
All right, and of course, for people that are unfamiliar with your voice, let's introduce you. You are, an estate attorney, but it's the end-of-life plans that we all need to think about and make, even though we don't want to, correct?
Yeah, I mean, that's all tied up into the same big category, I would say.
Yeah, and of course, there's a lot that people have to know. And your offices are located where, Richard?
We have our primary office in Goshen. We have also offices in Warwick and Monticello.
Wow. And how can people reach out to you?
Number is 845-291-0011, and our website is mid-hudsonlaw.com.
All right, and your office hours, please. That's also very important.
And generally, we're open 8 to 6 as a general rule, but hours can be flexible pursuant to each attorney.
And of course, if somebody wants to come in for a consultation with you, and they say, "Well, I can't get there till 9 o'clock at night."
I don't usually work that late, but I do have Zoom up available. One of the few silver linings of the pandemic was it allowed us or taught us to be more versatile in how we can meet with people. So there's usually when there's a will, there's a way.
Yeah. So now, one thing that we want to deal with here is when people have last will and testaments, and they have what do you want to call that person that is in charge of their last will and testament?
In New York, we usually refer that person as the executor.
Okay, and what is the executor's responsibilities?
Well, the executor's job is a few things. One is to marshal the assets and identify any liabilities of the deceased person. The decedent is the term we use. Bills that are owed by the decedent have to be paid first. Credit card debt, mortgages, things of that nature. And once the debts have been paid, the executor's role is to account for the assets and then distribute the assets to the beneficiaries pursuant to the terms of the will.
Right, and that's where an attorney like you comes into play, correct?
Yeah, we assist the executor, who by and large is a lay person, doesn't have the experience and knowledge of how the system works. So we prepare a petition for probate with the surrogate court, the court that people think of, another word is the probate court, where the will is administered in the county where the decedent lived. So we prepare that probate petition. We send the requisite notices to the beneficiaries and file the paperwork with the surrogate's court, and then once the executor receives what are called letters testamentary, that's the court's seal of approval saying we acknowledge the validity of the will and your role as the designated fiduciary or executor.
Right.
And once the executor has that letter testamentary, they can then address all the assets, work with the financial institutions, and we'll assist them with gathering those assets and distributing them to the beneficiaries and preparing the requisite accounting. If you have, say, 3 children named in the will, each they get a third, the question is a third of what? And so our job is to work with the executor, who in most cases will be one or more of the children, to show convincingly to the other beneficiaries that they're getting what they're entitled to, so that they will then sign what is called a receipt and release, basically a receipt to the executor acknowledging that I've gotten what I've entitled to. I'm not going to come back later and say you cheated me, and that's pretty much wraps it up.
So just because somebody at home right now that's listening has a last will and testament in place with an executor named, it's not all that easy, is it?
Well, it really depends on the case and the circumstance. Some administrations are pretty straightforward and simple. If all the family is very cooperative and everyone gets along well and no one questions what's going on, those probates can be handled very simply. But there are cases where there's family strains or missing beneficiaries. People don't always realize that while you are permitted to disinherit a child, for example, and that happens more often than I think people think, under the rules of what's called intestacy, if you have, say, 3 children and you're disinheriting them, and your will specifically says it, when you do have a probate estate, that disinherited heir has a right to appear in the probate proceeding to try to challenge the will if they are so inclined, and so they have to be notified of the proceeding. So one of the downsides of a probate versus a fully funded trust arrangement is that in probate, all the potential heirs have to be notified of the proceeding. Well, that's not necessarily the case in a trust administration if there is no probate. But once the heirs have been noticed and identified, they do have a certain period of time in which to file any objections to the will. Because if a disgruntled heir successfully can show that the will is invalid, and usually there are 2 primary areas of attack. One is that the person creating the will, the person we call the testator, didn't have the requisite mental capacity. An older person with dementia may not fully have the ability to articulate what their desires are. And the second, generally or often successful ground of attack is undue influence. Essentially, one or more of the beneficiaries have usurped the testator's own free will and basically said, Mom, you're leaving it this way or else, I'm throwing you out of the house kind of thing.
Oh.
So those are the 2 primary areas of attack. And it's not easy to prove that, especially because the person who might have the most knowledge of that is now deceased. But if the facts show it, and the will is in fact shown to be a product of, let's say, undue influence, the court may toss it, and if there is no valid will, and there are, say, the 3 children, they all get an equal share, even if it was evidently the testator's intent to disinherit one of those children. So that's where a lot of the interesting cases and complexity come into it.
With family, it can be really, really funny because I remember my mother's mother passing away, and my mom had two other brothers. And I remember, as a little boy, sitting down in my grandmother's apartment and having my mother and her 2 brothers argue over leather-top tables and who's going to get them. I mean, it sounds really simple, but you know what? It just adds so much stress to the situation.
It sure does.
When it comes down to things like that. So that's why when you fill out a last will and testament, you got to make sure all your T's are crossed and your I's are dotted. And that's where an attorney like you comes into play with this, correct?
That's true.
And if anybody wants a consultation with you and talk to you, how do they reach you again?
Yeah, the number is 845-291-0011.
All right. Richard, hang on. We got to take a quick break here, and we'll be right back with you, okay?
Sure thing.
All right. Richard Shapiro, and we're going to be finding out a lot more interesting stuff. Stick around. Oldies 98.9, the greatest music ever recorded. Maxine Brown right there. All in my mind. I'm Bob O, getting you over this Hump Day Wednesday morning. Very special guest, and he really, truly is and he's an attorney, of course, Richard Shapiro. And thank you so much for hanging out with us here.
No problem.
And I understand that you have an anniversary coming up, huh?
I do.
Yeah, and not only that, but you have a birthday next Tuesday.
Oh, that's true.
Boy, you really planned that good. How many years you and the missus have been married?
This will be 32.
Wow. Hey, congratulations to the both of you.
Thank you very much.
And a happy early birthday to you, Richard. And, of course,
Appreciate it.
we're talking about last will and testaments here. And, you know, this is I hate to put it this way, but in layman's terms, this is a real slick business, too. Because the executor, after this one person passes away, well, maybe even before this individual passes away, he could have, well, somebody write you out of the will and you wouldn't even know it. Does there have to be a reading of the will with an attorney?
No, not really. That's sort of more of a figment of movies and TV. It can be done, but frankly, just providing a copy of the will to the beneficiaries is sufficient.
And that's all it takes, huh?
Sure. And they can read it and then ask questions and either hire their own attorney, or if it's a non-contested kind of matter, the estate attorney is usually cooperative and helpful in explaining the requisite information to the various beneficiaries.
Now, what if the individual that passes has equity in a property or a home, and let's just say one family member objects that this other family member is getting more than he or she?
Well, that all comes back down to the testator's either competence or being subject to undue influence. Unless those two elements can be proven by preponderance of evidence, then the whatever their wishes are should be carried out.
Wow, yeah. So then there's a irrevocable trust, right? And a revocable trust?
Right. Wills are not the only way to pass assets, and in my estimation and practice, is not the preferred methodology. Trusts, living trusts as we call them, tend to be more comprehensive and better planned out than your average will structure, and they have the advantages I mentioned earlier of not being subject to the probate process to the extent that assets are owned in the particular trust.
Yeah, and what's the irrevocable trust?
Well, there are two basic flavors of trust: your revocable trust and your irrevocable trust. And there are many varieties of irrevocable trust. They have different purposes. Some in very high net worth estates are designed to be funded in a way to help reduce estate tax liability, which applies in this day and age to relatively few people. The most common use of irrevocable trusts in the average practice today is for asset protection for Medicaid or long-term care purposes. Essentially, the irrevocable trust is used to get assets into the trust well before a potential need for care might arise. And when I say well before, we're talking about the 5-year Medicaid look-back period. As long as you get assets in the trust at least 5 years before a nursing home Medicaid application is applied for, the assets in that trust will no longer be considered part of the assets of the person applying for Medicaid and will not affect their eligibility for Medicaid.
Wow, I gotcha. So, Richard, if you would, please, if people want to have a consultation with you or they have questions or whatever the case may be, how do they get a hold of you, please, again?
Oh, sure. The phone number for my office is 845-291-0011.
And what about your website address?
Yes, that is mid-hudsonlaw.com.
Now, if can a client, a potential client, get a hold of you through the website?
Yes. There is a contact form on our website. It's a well-designed website, and my own email address is listed there as well. So either way. But we get a lot of inquiries through the contact form that will ask what type of law you're seeking out. Obviously, if it's elder law estate planning, it comes to me. If it's for another issue, real estate or commercial transactions, it goes to the appropriate attorney. So there are many ways to reach us that way.
Our offices are located where again, please?
Right. My home base is Goshen. We have our offices also in Warwick and Monticello.
All right. Richard, I wish you a nice Memorial Day weekend. I also wish you a happy anniversary, and I also wish you a happy early birthday.
Well, thanks, Bob. Yeah, I have a lot going on.
Yeah, you most certainly do. I didn't get an invitation in the mail, though, for your barbecue over the weekend.
Fair enough. It's coming now.
I only want sirloin and lobster tail, okay?
Sounds fair.
Rich, thank you so much for being here with us. A lot of great information.
Well, good. Thanks for having me.
You're very, very welcome. All right, there he is, Attorney Richard Shapiro. Always a great time talking to him.